And now for a quick rundown of how different time periods have different rules for renewal. If the work has a copyright start date of 1922 or earlier, you don't have to bother looking it up. The copyright has expired. If the work is from 1923 to 1963, then you have to look for a renewal if you want to use the work without the authorization of the copyright holder or the would-be copyright holder. If the work is from 1964 to 1977, there's another little hiccup. In 1992, Congress passed a change to the Copyright Act whereby all works from 1964 onward were automatically renewed. Therefore, the copyright holder didn't have to bother with filing a renewal. The work gets protected for the maximum amount of time permitted by law without any additional effort on the part of the copyright holder. If the copyright has a start date of 1978 or later, there aren't two short terms, or there isn't just one short term. There is instead just one long term. One term of the maximum amount of time permitted. No renewal is necessary for 1978 works and works beyond that.
So everything you've been saying thus far breaks down into these various categories by year.
Insofar as copyright renewal is concerned, that is correct. However, some of the other disqualifiers of copyright apply differently. Earlier in this video, I was pointing out how an invalid or missing copyright notice would invalidate copyright. Well, that is certainly true for works prior to 1989. However, the law changed regarding copyright notices, and copyright notices became optional for works with start dates from March 1989 onward.
So this was changed in 1989?
The applicable law applies to works from March 1989 onward. The actual passing of the legislation occurred later and was retroactive with regard to those missing and invalid copyright notices.
I'm not sure I followed all of these details.
It's perfectly understandable if viewers of this video decide that they want to study an information table, such as the one at chart.copyrightdata.com, or want to study the various circulars offered by the Copyright Office of the United States, or want to read the actual text of the copyright laws themselves.
Does figuring out a copyright lapse ever get difficult?
Well, judge for yourself. You're looking right now at the opening credits sequence of the Fractured Flickers television series. And you'll notice at the end of the opening credits that the copyright date in the program itself says 1961. Now there is something wrong there. But for the time being, let's just turn to the closing credits of the program, where you see the date 1963, which incidentally is when the program actually did originally go on the air. Now, there's nothing that disqualifies the program from enjoying copyright by having a date that says 1961. The law just merely says there's conflicting information that the earlier date applies. As you can see right here, there have been court decisions on that. Now, here's where things get a little more sticky. The owners of the program didn't register for copyright until 1987. Now that's all right. There's been leniency in the Copyright Office, and they've allowed copyrights to be registered anytime during the initial 28 years.
But does that mean that the programs have a copyright start date of 1987?
As I was saying with the copyright notices, the earlier date applies. The earlier date is 1961. Therefore, add 28 years, you get 1989.
Well, it seems pretty obvious to me that anyone whose mind was on the ball in 1987 and knew to register them would write a note telling everyone in the firm that when 1989 rolls around, they'd better renew those copyrights.
I'm with you in that. I would do the same thing. But I gotta tell you something. I wasn't working for this firm. No one who thought as I did seems to have worked for that firm. 1989 rolled around, and there weren't any copyright renewals.
That's got to be the only time that somebody was thinking about filing all the appropriate paperwork and then, so shortly thereafter, not bothering with the renewal.
Well, actually not. And we can look at a particular court decision to show us that was not the case. These photographs of Marilyn Monroe were shot in 1962. They were first published shortly after her death. The photographer owned them. He did not file copyright until 2 decades later, but that was all right. That was legitimate. Just a few years later, copyright came up for renewal. He did nothing. The notion that he thought he had some time left comes across in the fact that he did attempt to stop copying that he did not authorize, but which it turned out was legal.
So what was the argument he tried to make?
That the placement of these photographs in a later work meant that the copyright in the later work controlled it. Now, I'm not going to go into the details here. There's a separate video in this series on derivative works.
Don't tell me that things can get more complicated than that.
Yes, they can, but that's outside what we're going to cover in this video. Those who study the issues and really want to test their knowledge may want to look at some exercises on the copyrightdata.com website. And with that, we finish this video, but there are others in the series covering subjects that you might want to familiarize yourself with if you plan to copy works where there's any doubt about whether there is or is not a valid copyright.